Hey, good afternoon, everyone. Thank you so much for joining us for our North Carolina Risk Management Summit. We have the pleasure of having today Kizzy Heath as well as Lynn Elders to present from NCREC. They both are attorneys. And then afterwards, we will have questions followed by John Waite from NC Realtors, who is also an attorney, to talk to us about North Carolina forms and what they're seeing from the NC Realtor standpoint. Following that, we will have our errors and omissions attorney, Daniel Peterson, join us, who is from Parker Poe. If you were on the earlier session today for the South Carolina Risk Management Summit, you do not need to stay once Daniel joins, but we do expect you to stay through the end of John Waite's presentation today, which will be approximately around 3 o'clock. As we get started, I know a number are still joining, but we want to be courteous of our guest time. And so Kizzy and Lynn, please kick it off. Thank you so much for being here. We appreciate your time and look forward to hearing from you.
Well, greetings. Good afternoon, folks. My name is Len Elder. I'm the Director of Education and Licensing here at the North Carolina Real Estate Commission. A lot of changes going on. Some of you may know we just added 2 new folks as commission members. Many of you probably know Cindy Chandler. Cindy Chandler served 4 consecutive terms. So after 12 years, she decided she did not want to seek reappointment. And the new commission member in her place is Bill Acito. And then Tommy Lawing, who also served 12 years on the commission, has stepped down, decided not to serve longer than that 12-year period. And Bob Ramsor, who previously was on the commission and served as its chair, is in that seat. Before we get started, particularly since we were introduced as attorneys, I need all of you to raise your hands. Come on, play along. And repeat after me. We can tell if your lips are moving. Len and Kizzy do not speak for the 9 commission members. So that'll keep Kizzy and I safe, so we have jobs after this meeting. One more. Right hands, repeat after me. Len and Kizzy do not give legal advice, though we have been introduced as attorneys. The real reason for spending some time with you today, thanks, Cindy, I see your hand up, at least in chat. The real reason for spending some time with you is just to give you some insight on things the commission has really been focused on with current complaints, investigations, how they've been handling some cases. And so if you haven't been keeping track, there are lots of statistics in this year's update course, but we are well at 50% of all of our cases dealing with misrepresentations, omissions, and biggest category of all, material facts. The update course every year is written by our legal education officer. That's Kizzy Crawford Heath. She's also the author of the real estate manuals. So I asked her to share some things with you that, quite frankly, we all should know, but may have forgotten about those important issues. So Kizzy, the ball is in your court.
All right, thank you, Lynn. I appreciate that. Good people, it is a pleasure to be here with you on today. I am an interactive presenter, so I see that you are already utilizing chat and you're utilizing your reaction emojis in Zoom as well. And I would like for that to continue because we're going to talk about misrepresentations and omissions. But before we can explain to you what the general statute states regarding misrepresentation and omission, we're going to talk a little bit about material facts as well. But first, in your own words, you can either unmute your microphone. I know I have about 169 of you in this Zoom call, so you can either unmute your microphone and someone tell me what is a misrepresentation, or you can indicate what a misrepresentation is in the chat box, and I'll give you some time for that. So in your words, what is a misrepresentation? Have you seen a misrepresentation as you're conducting a transaction out there in the Charlotte or South Carolina area? But we're specifically going to talk about North Carolina. I do see in the chat that some of you do brokerage in North Carolina and South Carolina, but just know we are the North Carolina Real Estate Commission, so we'll be talking about North Carolina License Law and Commission rules. All right, Susan says it is an omission of material facts. Chris says inaccurate, detailed information about a property. Michelle says the omission or the lie about a material fact. I see a lot of you are talking about omitting a material fact or providing inaccurate information. And I want to specify that misrepresentation of a material fact is when the broker provides inaccurate information to the client or the customer and the interested parties in the transaction. Now, the delivery of inaccurate information knowingly or negligently, meaning they didn't mean to do so, it doesn't matter. It's still a misrepresentation of that inaccurate information, and that is prohibited by North Carolina General Statute 93A61. I see that some of you were indicating in chat about omission of a material fact. So if misrepresentation is the delivery or the dissemination of inaccurate information, omission is when you fail to disclose that information. You fail to disclose the information maybe because you feel as though if prospective buyers know that information, they may be scared to purchase the property, or you just fail to adhere to your duty as prescribed under the statute. It doesn't matter why you fail to disclose that information. The duty to disclose the information wasn't conducted, so therefore the commission sees that as a possible violation of 93A6A1, that omission. Speaking of misrepresentation and omission, Lynn already mentioned to you that close to 50% of the complaints that we receive each license year fall under the scope of material facts. Now, we did not break down the statistics of material facts into what was actually misrepresented or omitted by the broker in the respective transactions. But I want you to know that there are a large number of complaints that we receive each license year that specifically focus on material facts as an issue. On average, over the last 4 years, we have received 1,500 complaints here at the commission. And when we talk about on average 1,500 complaints, these complaints that we receive are complaints that fall within our scope of authority, and some of those complaints don't fall within our scope of authority, such as commission splits or equitable distribution orders, things of that magnitude. You know, the rule and the law is very specific regarding what the commission has the authority to discipline. Speaking of those statistics regarding material facts, let's look at them. So 45% of our complaints deal with material facts, 14% deal with trust accounts, 6% licensure, 5% failure to report. When we talk about failure to report, there's a rule that indicates that brokers must report within 60 days to the commission the conviction of a felony or misdemeanor. All right, or if they enter into a consent order, or they're sanctioned by the notary commission. So there's a rule that says you have to report those convictions, and sometimes brokers fail to adhere to that rule. 4% of the complaints deal with big supervision. And when we talk about the 26% of the other category, what do you think that entails? Go ahead and tell me in chat. 26% of our other complaints that we receive, what do you think they focus on? I see that some of you are typing in chat, so I'll just wait. Sue says personal conduct. That is a great comment, Sue. We have what's called a prohibited acts rule, Rule 120, that talks about prohibited conduct and how brokers should carry themselves. Mark says agent professionalism or lack thereof. We do receive a lot of complaints here at the commission that says the agent was unprofessional or the agent did not communicate with me throughout the transaction. That does not fall within the commission's scope of authority, though. So those complaints are not sanctioned or disciplined by us because we don't have a rule for that. And so once you take this year's update course, we do a great job of explaining how, when a complaint comes in, a commission attorney views the factual allegations and ensure that it maps to a license law and commission rule. If those factual allegations map to a license law and commission rule, then that case goes further into the investigatory process. Depending upon the magnitude of the factual allegations, that case is then handed to a consumer protection officer or a field auditor or investigator by the commission. I see Carmanala says lack of knowledge. Yes, we really focus on the competency of brokers as well, ensuring that they are competent, they have the requisite knowledge and experience and education to conduct brokerage activities in any specialty area that they so choose. Now, once a broker passes the North Carolina license examination for real estate, that indicates they have the minimum competency that is needed to practice real estate brokerage. However, every area of brokerage is a specialty area. So if it's going to be residential, commercial, short sales, vacant land, then that broker should have that requisite knowledge in each of those areas to conduct that brokerage activity. If so, if not, then they need to really speak with their BIC to ensure that they have that information that is needed to conduct that brokerage transaction appropriately, because they're still going to be held responsible under the commission's purview for the reasonable standard that a prudent broker who usually practices in that area uses to conduct that brokerage activity. Now, speaking of misrepresentations and omissions, the North Carolina Real Estate Manual really lays out the commission's policy and viewpoint on how we look at misrepresentations and omissions of material fact by real estate brokers. And so I hope that each of you have what I call that guidebook to brokerage, that North Carolina Real Estate Manual. We do have two versions available, the hard copy and the digital subscription as well. You know that the hard copy is updated every other year, but that digital subscription, which lasts you for 2 years, is updated consistently. We have a plethora of rules for licensed law that we deal with as well. And I want to bring your attention to 93A6A1. And this rule specifically talks about a broker who participates in willful or negligent omission or misrepresentation of material fact can be disciplined by the North Carolina Real Estate Commission. I want each of you, by a show of hands, it can be your physical hand or an emoji, to let me know if you tune into our commission business meetings each month. And keep your hands up. I'm just going to go through the screen to see. Okay. If you are not doing so, I strongly encourage you to do so. Lynn made you aware that we have 2 new commission members on the commission. Each year, the commission's position may change regarding some of the requirements and duties that brokers must adhere to. If you listen to our commission meetings, you will know that this sitting commission is really concerned about brokers and their failure to discover and disclose material facts and their BICs as well. Every time a complaint comes up and it is investigated, and then the attorneys go to the commission and ask them to find probable cause to take the case to hearing, the commission members will always ask, okay, can you tell me the facts surrounding what the broker did not do regarding the material fact disclosure? Once the attorneys communicate that information to the commission members then ask, okay, where was their broker in charge? Where was the broker in charge delegate? And so now, if you look at the e-bulletin that is sent to you each month, and if you scroll down to those disciplinary sanctions, you will see that a great majority of those sanctions deal with brokers who are not meeting their mandatory duty to discover and disclose material facts under General Statute 93A6A1. There are 4 categories, and we like to say checklists, but we use the word categories because these are the categories that you can use as a broker when you are visually inspecting a property, when you are having a conversation with your client or your customer regarding what the issues are with the property or what their wants, needs, and desires are regarding a property. And so we're going to quickly look at the 4 categories of material fact. And I know you're thinking, Kizzy, we always talk about material facts, and I'm here to tell you that we're going to continue to talk about material facts and stress the need for brokers to adhere to their affirmative mandatory to do so, because we have all of these complaints that continue to come in to the commission. So the 4 categories are: 1, facts about the property itself; 2, facts that relate directly to the property; and 3, facts affecting that principal's ability to consummate the transaction. And then that last category I indicate is very subjective. It is facts of special importance. That's going to change depending upon who your client is. So regarding facts about the property, what are some examples that you have noticed prior to you listing a property that may be some material facts about that property? You can go ahead and tell me in chat. And these are factors that are internal to the property. And so when you think about facts about the property, I want you to think about things that are internal to the property. Thank you, Nick. Nick says whether or not the property is within a floodplain, Minnie says whether or not a permit was pulled. Erica says a leaking roof. Karen says mold. Thank you for your comments. And yes, whether or not the roof leaks, whether the property has foundation issues, malfunctioning appliances, and health or safety issues as well. All right, keep the chat box rolling. What about facts that relate to the property? The facts that relate to the property are those factors that are external to the property. They may affect the desirability, the use of the property. So factors that are external. All right, thank you. Environmental issues nearby. Margaret says the widening of a street. Arlene says in-ground tanks. Chris, new development in the vicinity. Thank you for your responses. External factors deal with zoning, road improvements as well. All right, let's look at facts that directly affect the principal's ability to perform. What is something that can affect whether or not the principal can complete the transaction? Heather says death. Blake says liens. Chris says a seller is underwater. Clean and clear title. Marilyn says divorce. Thank you. Sarah says loan approval. And Mark says mechanical liens, followed by Arlene that says mortgage approval as well. And you are correct. Loan denial may prohibit a principal from completing their transaction. If they have the inability to convey clear title, that may interrupt that transaction as well as bankruptcy. Now, one thing that you also want to keep in mind that's a red flag, if you have a potential principal that says, look, I'm going to purchase this property with cash, and then something happens, and now they have to go to a lender to actually finance the property, that's a change in the terms in which the contract was entered into. And so now that is a material fact that must be disclosed to all parties in the transaction. And so you have to keep that in mind as well. And of course, any pending foreclosure can prohibit that principal from completing the transaction. Now, the facts of special importance, again, are subjective. Now, I will tell you sometimes I troll MLS or the Realtor app just to view some of the advertisements or descriptions that brokers are placing out there for the properties. And I am very alarmed at what I see oftentimes. One advertisement I saw is that, you know, this property has a material fact. A dog occupied the property. Whether or not a pet occupies the property, that in and of itself is not a material fact unless your client indicates that that is something that is of importance to them. They need to know whether or not the subject property has been occupied by a pet. But if your client doesn't tell you that information, that's not a material fact. If your client says, I need to be near an exit because I want to be 15 minutes away from my job, or I need the door facing north because of religious preferences. Those are facts of special importance. Again, they're going to be subjective and they're going to change depending upon who your client is for that particular transaction. Minnie says, especially a cat and the buyer has allergies. Yes, great example, Minnie. I appreciate that. Whether or not a property is within city limits may be a fact that is important to the buyer, whether or not they can operate a home-based business, such as a daycare center or a boutique within that property as well. Will it be in adherence to any restrictive covenants that may or may not be in effect? Karen says rental restrictions. Yes, that is a great example as well, because there may be some rental caps for respective neighborhoods. Thank you, Karen. Now, although we talked about the 4 categories of material facts, I still want you to be cautious and cognizant of other red flags that you may see. Now, in this year's update course, we talk a lot about red flags and how brokers need to pay attention to why buyers pulled out of contracts or terminated contracts when the property was previously under a contract. And so ask questions regarding why a buyer terminated a contract, especially if you see that the property was under contract 3, 4, and 5 times. You take that information and you have to ensure that that information is disclosed to all parties and future buyers. So oftentimes the reason for a buyer's cancellation may be a material fact. And if it is a material fact, then that disclosure must be made to subsequent buyers. And it also may lead to the amendment of the seller disclosure, the RPOADS. Now, I want you to remember that the seller disclosure, the RPOADS, if a seller chooses no representation on that RPOADS, but the broker is aware of material facts that relate to that property, that broker still must adhere to their mandatory obligation to disclose those material facts to all parties in the transaction. So the way the seller answered the RPOADS does not negate, does not void the broker's mandatory affirmative duty to timely discover and disclose material facts. I know that I'm speaking a lot about material facts and I discussed the 4 categories. I take questions at all times. So if you have questions, you need a clarification of a point, or you have an aha moment, you can either raise your reaction hand on Zoom, or you can put your question in chat. Please ask any questions or get any clarification that you need while you have Lynn and I here. Now, misrepresentation and omission of material facts can lead a broker to be possible in violation of 3 things. Check this out. 1, the commission can say, look, you failed to disclose material facts. You made a false promise to a client or a customer, or you participated in misrepresentation. All right, I see I have a question in chat. Give me 1 second. Liz says, is the MOG required for condos when the owner doesn't own the land? Mineral oil and gas rights disclosure is a seller disclosure. And I'm going to refer to Lynn. Lynn, don't they have to do the MOG if the seller is a condo? And Lynn says yes. And yes. I will tell you, when we approve the new version of the RPOADS, which hasn't been officially approved yet, but when we approve the new version of the RPOADS and the MOG, you will see instructions to brokers at the beginning of the form. And these instructions provide you with a statutory reference, and it gives you instructions as to what your duties are as a broker and what the sellers are required to do as well. All right. I see that I have, I opened the floodgates. Now you guys are asking me questions. I love it. Tiffany, I am to your next question. There are often questions as to how much an agent must disclose from an inspection report when a buyer terminates. Great question, Tiffany. So once a listing agent gets that inspection report, or they are made aware of material facts from that buyer's inspection report, they have to disclose all of the material facts. Even if the seller says, I don't want you to disclose this information, remember the law says that you must follow the seller's lawful objectives. If the seller tells you not to disclose material facts, that's not a lawful objective or directive. So you must disclose all the material facts regarding the property. Great question, Tiffany. If a home has a defect that has been repaired, does it still have to be disclosed? Great question, Melanie. And so that defect, you have to analyze, okay, what is the probability that this defect may occur again in the future? Has it fully been repaired or resolved? Is there documentation? Are there repair records? Do you have an invoice or a receipt from the contractor that performed that repair? So ask yourself, what is the likelihood or the probability that this issue may occur in the future? In my personal opinion, if I was practicing brokerage and I was made aware of an issue such as a leaking roof that was repaired and I became aware of that, I would cover my assets and still disclose that information. Okay. Erica, I'm down to you. Is it best to share the inspection report so I don't have to decide what is material and what isn't? I can't give you any advice in regards to the inspection report. I will tell you, Erica, this is a great question for you to discuss with your BIC. And your BIC will determine the policies that the agents must follow in that particular brokerage. And so that is definitely a big question. The commission can't advise or tell you this is in your best interest, this is what you should do. But thank you for that question, Erica. And Martin, I'm to you. Is it the seller's broker's responsibility to disclose the reason a contract fell through? Now, if the seller's broker is aware of a material fact regarding why the contract fell through, that broker must disclose that information to subsequent buyers. If it's not a material fact issue, then you follow the lawful directive of your seller. Great question, Martin. You guys got awesome questions. Chris says, what is the best way to make buyer agents aware of material facts? Awesome. In last year's update course, 2022-2023, we had a whole section on material facts. And the commission says you can disclose material facts in the public remarks section of the MLS. You can do it via email, or you can do it via text message. You could do it by attaching supplemental documentation, right? So in the public remarks of the MLS. Amy says, what if the buyer didn't share the inspection report and backed out with no knowledge as to why they backed out? And so if they don't provide you with the inspection report, if they don't tell you what their home inspector indicate, then, you know, to cover your assets, you could essentially say that we had this property was under contract with another buyer, but the buyer canceled the contract. If they ask you why, you're not lying if you say, I don't know why the buyer terminated. It was a personal reason. Again, if you know of a material fact, should know, have reason to know, then you must disclose that information. And I'm going to come back to some of these questions. Let me go a little bit further to the prohibited conduct of misrepresentation and omission, because Tiffany only gave me approximately 45 minutes, which incorporates questions and answers as well. So I want to try to adhere to that time limitation. But again, misrepresentation is that communication of misinformation. And so what if a broker says, look, there aren't any problems with the roof, however, I haven't went up there to look at it. That could potentially be the communication of misinformation or given inaccurate information. And I will tell you, this is the most common form of failing to adhere to material facts that the commission sees. Omission is that failing to disclose. So you're failing to disclose information that either you should have known or that you know, but you don't want to share because you think that it's going to prevent the transaction from moving forward. Some of the most common misrepresentations that we see deals with square footage. We had a case, and again, our hearings are live as well, and you can listen to them on Zoom on the Thursday and Wednesday of a commission meeting. We have a link on the commission's website, but we just had a square footage case, and misrepresentation of square footage is a huge issue out here in the brokerage community. Now, the commission says that you as a broker do not have to disclose square footage. Square footage is not a material fact. However, if you're going to state the square footage, it must be accurate. It must be accurate. You can't rely on blueprints. You cannot rely on tax records. We actually have a commission publication for you to use, which is entitled the Residential Square Footage Guidelines. You can rely on your own measurements. If you would like to hire an appraiser or another vendor to measure the property for you, that is fine. However, you need to get copies and documentation of their measurements and ensure that they're in your transaction file. Now, the buyer agent can reasonably rely on the square footage measurements of the listing agent. However, if the buyer agent is suspicious of the square footage measurements, then they need to make the listing agent aware, because that is a material fact. Inaccurate square footage is a material fact. So again, you cannot rely on tax records or blueprints for the square footage of a property. How many of you actually read the articles that we post in the e-bulletin each month? Thank you, Tiffany and Christy and Millie. Those articles live on the commission's website. Let's say you want to know the commission's position regarding square footage, but you don't remember the title that Kizzy just gave you of an article. You can go to the commission's website and you can type in square footage, and all of the articles regarding the commission's position for square footage are going to populate for you. And one article that I really want each of you to read, because it allows you to be proactive instead of reactive once an investigation starts, is your square footage measurement must be right when listing a property. And again, you use this residential square footage guideline to assist you with defining what is a living area, how you should count stairways, and it also provides you with a lot of examples and diagrams. So now let me go back to chat and see where I left off at. Lee, I'm here with you now. Lee says, how do you handle it when buyer's contractor and seller's contractor disagree with remediation and the buyer terminates due to the recommendation of their contractor, but the seller repairs due to their contractor's recommendation? I will tell you that that is a big question. The commission does not advise, does not dictate how you should remediate or negotiate with a vendor for another party. And so as brokers, I know it's kind of hard sometimes for you to visualize the roles of the different agencies and associations in your brokerage. And so we have this great publication called Whose House Is It? So when you think of the commission, I want you to think about license law and commission rules. We are the governing body that regulates real estate activity. We state what are prohibited acts of conduct. We state that all advertisements must be free of discrimination. And when you think of your brokerage, that brokerage provides you with policies that you must adhere to as you are representing clients and interacting with customers. So that brokerage may say, okay, this is the type of agency that I will allow you to engage upon. This is how your compensation is going to be paid. This is how you're going to communicate with parties. This is your BIC delegate. This is how you communicate with your BIC if you have questions. And then you have your Realtor Association, if your brokerage is a part of that, that you interact with MLS and you enter into agreements with other cooperating brokers. And so again, the commission, we don't give advice. This is a great question for a BIC, and I hope that I explained that thoroughly regarding whose house is it. All right. Nidra says, if the broker has not seen the inspection report, do they still have to disclose, since at that point it would be hearsay? So let's say Kizzy is your buyer and Nidra is the listing agent, and Kizzy gives her broker, Lynn, permission to tell you why I'm not following through on my transaction. The roof is leaking, there is no sump pump for the property, the driveway encroaches on a neighbor's yard, whatever the reason is, all three of those are material facts. Although I didn't give you the inspection report, I provided what alludes to be material facts. So what that listing agent should do is take that information and do their due diligence to find out if that is in fact a material fact, because what Kizzy's broker just discussed with you is a red flag. So it should have your antennas going up and say, okay, does the driveway encroach on the neighbor's property? Does the roof leak? You have information, and you just can't take that information and sit on it. You have to go forward and conduct due diligence to see if that information is correct or not. Martin says, we have gotten pushback from home inspectors for sharing the information contained in the inspection report. I will tell you the commission has put out information in our update course regarding the inspection reports. And, you as a broker, you don't have the ability to share the inspection report unless your client says, look, you can share this inspection report with the listing agent. So if Kizzy is the buyer and Lynn represents me and he's the broker, and I give Lynn permission to share the inspection report with the listing agent, who is Millie, Millie has the inspection report. Millie must disclose the material facts, update advertisements, and so forth, and make sure subsequent prospective buyers know that information. Okay. Let me make sure I don't have any other questions. All right, Cindy says, what if you get two different numbers from two separate measurements? The case last month had 3 different measurements, and 2 were from appraisers. And so what you would do if you get a property that has 2 different measurements, you would include both of those measurements in the transaction file. You can use as a reference or a guide the tax records to see if there was something added to the property per se. You can't use that tax record as the end all be all for the square footage, but you can use it as a reference to see whether or not there was an addition to the property. But if you have 2 different measurements, the residential square footage guidelines indicates that there is a less than 5% deviation that the commission will not investigate brokers for. And so as long as it's within that less than 5%, there won't be any issue. But again, personal opinion, if it was me and there are 2 different measurements, I probably will go to a 3rd and 4th, depending upon what my BIC told me I must do to cover my assets. Okay. Great question, Cindy. And I am all cut up on the questions.
I have that going on right now. That's why I asked.
Great question. I know I probably didn't give you the exact answer you wanted. However, what were you leaning towards, Cindy? Were you going to go get a 3rd measurement?
Yes, that's what I was thinking.
Great.
Best 2 out of 3.
Great.
It's only like 128
you,
square foot. It's like 3.5% difference, because I already did that math too.
Right.
But still.
Right. And so that's great that you're going to get that 3rd measurement. And then I told you about the commission's position with less than 5%. And so what you should do is All of those measurements that you receive, Cindy, you should include those in your transaction file as evidence and to support your documentation or your description of the property after you speak with your BIC, of course. All right. Other misrepresentations besides square footage that we see at the commission, of course, if a broker reports the wrong square footage, they're going to be investigated. An inquiry is going to be conducted. Investigators may come knocking on your door. It's a whole process, and you'll learn more about that process in this year's update course. And so there's going to be an investigation if a broker states the wrong square footage and the advertisement. But other misrepresentations that brokers participate in deal with septic and sewage systems as well. Remember, you have to state the sewage system that the property is on, whether or not it's municipal, community, or on-site. And you don't want to confuse and say, okay, this property is connected to a municipal system when it's actually a combination system. And so if you are not familiar with the types of sewage systems, we do have an article on the commission's website that explains municipal combination and on-site septic systems as well, sewage systems as well. There are some best practices that brokers should implement before advertising the number of bedrooms and whether or not the sewage system is municipal, combination, or on-site. Verify the permit, pull the permit from the local municipality. You can also contact the North Carolina Department of Environmental Quality. We go over all of this in last year's update course. And by the way, our update courses, if they are not older than 10 years old and the information is still law, you can find them on the commission's website. And so you can go to the commission's website and find the material facts section of the 2022-2023 update course. And we talk specifically about septic and sewage systems and flood zones and square footage guidelines. We give you all of that information. So once you sit and you take the update course, that information shouldn't be lost upon you. You should use that update course as a resource and a guidebook and take it with you when you are conducting real estate transactions. Another misrepresentation are street disclosures and road maintenance agreements. Brokers are not discovering and disclosing whether or not the street is public or private and who has the responsibility to maintain that street. That third violation that could possibly get a broker in trouble is the making of a false promise. We see this when a broker gives a promise to a client or a consumer that is going to either induce them, persuade them, or bribe them to complete the transaction when they would not otherwise complete it. And the broker does not follow through on that promise. The example that we provide in this year's update course is this. And all of the scenarios we provide you in the update course are true scenarios. We get them from the allegations within the complaints that we receive here at the commission. So we had a buyer agent who represented a buyer, and the buyer agent said, look, buyer, if you follow through with this transaction in this addendum, I'm going to give you $5,000 once you purchase this property. The buyer's agent home inspector said, look, this HVAC system is faulty. The listing agent and the seller said the HVAC system was new. The buyer agent agreed with the listing agent and the seller, did an addendum to the contract, told their client, I'm going to pay you $5,000 once you complete the transaction. The buyer completed the transaction. The buyer agent did not pay the $5,000. That's an example of making a false promise, inducing the buyer to complete the transaction. Although we talked about licensed law and commission rules and the broker's affirmative mandatory duty to timely disclose material facts, I do not want you to forget about federal law and state law as it pertains to the Deceptive Trade Practices Act. This relates to brokers as well because you're engaging in transactions which affect and deal with commerce. So any of the statements that you make that induce fraud or that provide inaccurate information, you can be civilly liable for. You can be liable for damages, cost, and attorney fees as well. And when we talk about deceptive trade practices, we're talking about anything that you communicate that violates industry standards, that substantially injures consumers or has the tendency to deceive a consumer. you may be in violation of the Deceptive Trade Practices Act. Give me 1 second and let me catch up on chat. I see Tiffany is saying that oftentimes deceptive reports are no longer on record at the county based upon the age. Is a written notice from the county appropriate record? And how do you handle this when multiple bedroom counts have been previously reported? All right, so yes, documentation and transaction file that you've done your due diligence as a broker and contacted that local municipality to try to obtain a septic report should be noted in that transaction, okay? Just in case the commission ever comes a knocking, you have that information in there that you attempted to do your due diligence. Now, in regards to previous advertisements indicating that there have been multiple bedrooms and you don't have the evidence to support the number of bedrooms the septic system permits. Again, I would look at the tax record as a reference to see if there have been any additions to the property. But as a broker, you are responsible for the advertisement that you disseminate. And remember that you want to ensure you do everything that you can after you have that conversation and you inquire with your seller and you talk to the local municipality, that you have all of the information that you need before you put forth that advertisement. Because indicating in the description, buyer agent to verify square footage or number of bedrooms is not sufficient. It is not appropriate. It is not enough to prevent the commission from investigating you on their own initiative or upon the filing of a complaint. Okay, thank you, Tiffany. Now, there are some best practices that I want you to walk away with this presentation with. When you are practicing brokerage, do not make any statements without first verifying or validating that information. You need to research the property-specific information to ensure that your client can use that property for their intended purpose, or that customer can use the property for that intended purpose that they have. I spoke to you about the sewage system and how you have to accurately state the sewage system that the property is connected to, because if you state the wrong sewage system, that is misrepresentation of information, and that is a possible commission violation. Make sure you check permits for the number of bedrooms that the septic system permits. Also, brokers should be knowledgeable about some of the exceptions to the septic permit as well. So, some septic permit says you can't attach a dishwasher to this property. You can't have more than 2 bathrooms on this property. So verify and validate and do your due diligence. Please do not rely on tax records. In the hearing last month, when the broker was testifying on their own behalf, they indicated they relied on the tax record. We tell you specifically, do not rely on the tax record. You can use it as a reference to help you in the research process, but you cannot use that square footage that is provided in the tax record, nor can you use the blueprint to provide you with the square footage information. And a red flag is any discrepancy that you notice when you are researching that property specific information, or if you receive information from a buyer agent, listing agent, or prospective purchaser regarding the property. Those are instances of which red flags have become known to you, and the commission sees red flags as an indicator that something may be up with this property, and it is up to the broker to go forward and conduct additional research. Now, if you have any questions about anything that I covered with you today, I will tell you my email address is just my first name at ncrec.gov. I am here. Tiffany knows how to reach out to me. Haley knows how to reach out to me. I believe in establishing a great relationship with brokers so that you are in adherence with license law and commission rules at all time. But if you need me, you can always reach out. But if you have questions about law or interpretation, here is Regulatory Affairs' telephone number and email address as well. You can always reach out to them. And let me look at some of the questions I have in chat. Mark says, is a buyer agent even allowed to give money to the buyer after the closing? Mark, I'm gonna say, that looks like some murky waters here. Why is the buyer's agent giving money to the buyer after closing? Why is this information not on the closing disclosure? What is the nature of this money changing hands? Does your BIC know that the buyer agent wants to give the buyer money? I mean, there are some exceptions in the law that says that you may pay compensation to a party in a contract, and if you so choose, but it has to be specifically disclosed on the closing statement. So I would love to know more about that as well. Thank you, Lynn, for my private message. I appreciate that. I'm going to turn this back over to Tiffany or Haley. Lynn, do you have anything you would like to add, sir? Lynn says no, he does not have anything he would like to add. I'm going to hang on for a minute to see if Tiffany or Haley has anything for me before I buy out. Hopefully, you have learned a lot today. If you need me again, I am here. Thanks.
Thank you so much, Kizzy. That was great information. It looked like everyone was learning something, and I loved how we all participated and shared information. It was engaging, and that time really flew by. So thank you so much. You made it quick and fun and very educational. And Lynn, thank you so much for your leadership as well and for being here. We really appreciate both of you. And as we move forward, we have John Waite up next, who is already here. He is our next participant, and he will start sharing his screen momentarily. John Waite is with NC Realtors as well as an attorney with Martin and Gifford. And so please let us welcome him. And I'm going to remove Lynn's pen, and I am going to, there you are. Go ahead, John. Thank you so much for joining us today.
Yeah, thanks so much. Yeah, my name is John Waite. I'm a partner at Martin and Gifford. We're located in Winston-Salem. We're a law firm that pretty much focuses exclusively on real estate brokerage. And as Tiffany mentioned, we are general counsel to the state association. So we do a lot of their legal work. We do specific things for the association. Some of you may be familiar with the chief legal counsel, Caitlin Thompson. She is in-house counsel with NC Realtors and the chief legal officer there. They also recently hired another in-house counsel over there to help out with certain things. Our law firm does some ancillary things for the organization, and I'll just go through those briefly. The first thing that we do that you may see is every Monday, the Realtor Rundown comes out, and we write a legal Q&A for that. That comes from our law office. Another thing that we do is we operate the legal hotline. So I'll give you that information in a minute. It'll be part of my presentation. If you don't already had that information, it is a free benefit of your membership. Being a realtor, you can call or email the hotline. Generally speaking, either me or one of my other 3 partners is going to get back to you same day. But I will say this, call volume has increased every single year I've been here for the last 8 years. So it's becoming more and more often that if you don't get your question in by 4 o'clock, chances are you're going to roll over to the next day, simply because my family would like to see me at some point. I don't know why. They don't like me that much, but they do seem to expect me to come home at some point in the evening. And if I spent all my time responding to all you people who decide to email and call late in the day, that just wouldn't happen. So just understand that that's probably one limitation we have. And depending on call volume, sometimes things roll over. We have meetings and conflicts that come up occasionally. So just understand it. But generally speaking, probably 90% of the time, you're going to get a call back or an email back same day. And then finally, one of the big things that we do, and primarily my position at the firm, is we help draft forms. And I want to, before I even go into my presentation, I want to talk about the forms committees a little bit, just because I feel like it's helpful to give you the context that you need. Every July 1st, we release forms changes, right? Those forms changes are not created in a vacuum. I don't just sit behind a computer and think of all sorts of ways to torment you with forms changes. Although that does sound fun to me, I mean, that wouldn't be beyond me. I mean, I would do that just for fun, but I don't, okay? Forms is instead it's a year-long process. The first, committee I'll talk about is the forms committee. It is a realtor-led committee. I mean, it is part of the state organization. I'm the lawyer that sits on there and helps draft the stuff for the committee. The committee is anywhere from 20 to 25 realtors at any given time, plus Charlie Moody from the Real Estate Commission is also a voting member of that committee. So we get the commission's input on forms changes like in real time, real input, real discussion about proposed forms changes. So any of the forms that you see that have the -T on them, okay? Most of those forms are joint forms, not all of them, but most of them. And so any of those forms, like for example, Form 2T, the standard offer to purchase a contract, that form is -T, right? So that form, like all the -T forms, has to go through a second committee before it can be used and approved for July 1st. And that committee is called the Joint Forms Task Force. And what that is a committee made of a mix of realtor members and closing attorneys who are members of the real property section of the North Carolina Bar Association. And that committee, the size of it will vary, meeting to meeting, but generally speaking, You know, a lot of times that meeting will be around, 15 to 20, lawyers and realtors together. And they'll be discussing things that come from forms committee. Like if something's already been approved at forms committee, it'll go over there, has to go through there and be approved there first. Then all forms, even after all that. So, if a -T forms go through both those bodies, or if it's just a form that's, say, like a form 101, the exclusive right to sell listing agreement, that doesn't have a -T on it. That's not going to go through joint forms. Okay, so that just goes through forms committee. But all the forms would then have to be approved by the North Carolina Realtors Executive Committee. Some of the members of the executive committee do serve on the forms committee and are pretty educated members about the forms changes that come out. And also the real property section of the Bar Association has to approve changes to any of the -T forms. So it's why, we are in the middle of forms now. Basically, the forms come out July 1st. We start the next form cycle, making the changes for next year in August. It goes all the way through about April. And then between May in June, me and the staff at NC Realtors put all the finishing touches on the forms changes and get them ready to send out to vendors. So I feel like that's important because sometimes forms changes come out and people want to, shoot the messenger, and that's all fine and dandy. If you want to shoot the messenger, go right ahead. I'm not beyond that myself, but just understand if you shoot the messenger, you don't accomplish anything. So just know where you need to direct your stuff. If you have form suggestions, you can email them to me or the hotline. And you can also, there's a forms email actually where you can send them to, and Lee Morgan, who's the paralegal at NC Realtors, is maybe the most important person there as far as my contact goes. She will take them and collect them, and she's the one that keeps us on a straight track over there. All right. So all that said, what I've got, as I mentioned, I do the hotline. I did the hotline this morning. I do it 4 days a week. And what I've got today to go through with you is the most common questions I see in the hotline. And it was pretty interesting listening to Kizzy because some of my questions on the hotline actually overlap with hers. And I think I'll have some different input to give to some of the questions that come up just in the part of her presentation that I saw. Now, mind you, and I mean this very seriously, if anything I say contradicts Kizzy, please put it in the chat. It's not my intent to contradict her at all. We do our best to keep up with the commission's positions on things to make sure that we give you guys the best advice possible. So if anything I say differs from that, please let me know. Don't be afraid. It's perfectly fine. And hopefully it's just maybe I miscommunicated, or maybe there's some kind of middle ground or a piece missing to make sure that we know that. Anyway, I'm going to go through these rapid fire. I got 15 of them. Hopefully I'll be able to wrap this up about 1:45, and then you guys will still have some time for some Q&A, which I'm sure you may have. I would suggest holding your questions till the end. Once we get to the end, I'll go through the chat and go through raised hands and things like that. So number one, and these are just common questions we got on the hotline. Not all the common questions, but just 15 of them that pretty routinely come up. Can an agent sign for a client? Generally speaking, no. Nothing about you being a licensed broker gives you the authority to sign for a client most of the time. In order to have that authority, you need to have a power of attorney or something like that. That said, even if a client is asking you to do that, and occasionally brokers will call saying, hey, my client wants me to get a power of attorney so I can sign for them. And I tell the agent, no. Find anybody else. Okay. This has nothing good for you at the end of the day from it. Sure. Can you do it? Can you get a power of attorney and do that? Sure. But you cannot erase the fact that you are getting paid on this transaction. You just can't. And if something blows up, they are going to point fingers at you because you got money as part of it. So even though you may have a client who really wants you to do that, my advice to agents is don't do it. It's really not worth it. Find somebody else, anybody else, to take that authority for the client and sign for them. Okay. Question 2. This has to do with Form 390. This used to be a question that came up a lot more before the most recent round of forms changes, which I'll talk about more in a minute. But Form 390 is the termination form that has signature lines for both the buyer and the seller. So both parties have to sign in order for it to be an effective termination. It's effectively an agreement to terminate. Okay. So the question is, the seller, the buyer sends Form 390, which has this, dual signature requirement. Seller refuses to sign it. Due diligence period ends. Is a contract terminated? And we had to answer this, years, we've had the same answer for years and years. The answer is maybe Maybe, because you have to piece together whether there's a termination based on the communications that surrounded the Form 390. Now, I don't need to probably explain to you that maybe is a very bad answer in this context. It is good for nobody. It is not good for the listing agent, especially, and the seller. They're the ones bearing most of the risk here, because if it's not terminated, they sign with someone else, then you've got a real problem, right? So last form cycle, we tried to address this and try to cut down on these questions by adding 2 new checkboxes to Form 350. 350 is the unilateral termination form that the buyer sends over. And in that, you now have a checkbox that says buyer doesn't give any reason at all. They're just terminating, okay? Send that. Send anything. Send the unilateral termination. Give finality to the end of the contract. I implore you, please. If you send Form 390, and you've got a nasty little email that says, that goes along with it, that says, my buyer hates your guts and we hope you rot in Hades forever. Okay, that's probably a good enough indication that the buyer clearly intends to terminate and the transaction is over. Is that something you really want to rely on? I don't know. I don't know. Probably you can, but it's just a gray area in most cases, and it's a gray area you want to avoid. So as much as possible, if you got a buyer who definitely wants to terminate, use Form 350. That will preserve their ability to go after the seller in court for whatever they want, because there's no release in Form 350, the unilateral termination form. 390 does. If you get the parties both to sign 390, there's a release in there that says nobody's going to sue anybody and everybody's going to go on to their lives and be happily ever after. If your buyer really wants the ability to go after the seller in court to potentially get back, say, a substantial due diligence fee or something like that, then you need to preserve that, and Form 350 is a much better fit. So as much as possible, if you got a buyer who wants to terminate, send 350. If you can get a good agreement with the seller, great, but don't just fire off Form 390 and pray that the transaction is terminated. That is a recipe for disaster pretty much every time. Question number 3, how do you sell estate property? The answer to this is relatively simple. You're going to need to get a lawyer. Okay, you just are. Especially if you are on the listing side, figuring out which parties need to sign and spouses and all the things like that, you're just going to need a lawyer to do it. Now, that said, this form cycle, I am working with Joint Forms and with the Forms Committee to adopt a flow chart that will at least help you try to more accurately identify who the seller actually is and who needs to sign. Okay, hopefully that'll come out. Has not been approved yet, but if it comes out July 1st, look for that, pay attention to it. We've tried to make it very easy to follow so that if you get an estate property, then you know who needs to sign in order to at least get the initial paperwork done. You're probably still going to need a lawyer to take you through the transaction, but it'll at least give you, a good first step and make closing attorneys happy, which I know most of you probably don't care about. Closing attorneys are the worst. Lawyers are just the worst, but that aside, it's good to have a good working relationship with them to make sure that, your transaction goes the way it needs to. I'm just saying, it's not a bad thing. All right. Number 4, what if the buyer fails to timely deliver monies? And usually there's a corollary question with this of, is it an effective contract? So let's start with actually the second question. Isn't it an effective contract? Yes. Yes, it is. Pretty much always. As soon as the contract is fully signed and the last person who signs communicates to the other side that there's been a signing, that's it. The definition of effective date is very clear in the contract. There's very little ambiguity there. You don't need to even send the fully executed contract back to the other side. As long as you communicate, you send a text message, you do a phone call, smoke signals, whatever. If you communicate to the other side that, hey, my party has signed and they were the last ones to receive this thing, either an offer or a counter offer, then you're under contract. Okay. So what if the buyer then fails to timely deliver the money? Well, you can, as a seller, you can make a demand for that money, and Form 355 is a pretty good tool to do that. And then the buyer has one banking day to pay. And if they don't, then the seller has the right to terminate the next day. And you can use the seller termination form, the unilateral termination form. That is Form 352, I believe. And just go on to the next buyer. And your seller has to decide whether they want to go after the buyer for the due diligence fee or not. I just talked with an agent this morning about that. The answer to that is, if your seller's really bent on going after the buyer for the due diligence fee, make sure you just tell them to go get a lawyer and back out of it as soon as you can. It's not brokerage. It is litigation at that point. It's just legal related, and there's not much you can do about it. So just back out, move on, and keep trying to sell the property if that's what the seller wants to do. Question number 5. What happens to a tenant when the buyer buys a rental? The buyer is going to step into the shoes of the current landlord. That's it. So if it's a verbal, oral, written, doesn't matter what the lease is. If it's a grandson who just, wandered in there with grandma's permission, that's a tenant. It's a tenancy at will, terminable at any time. And you might need a lawyer to get them out because most magistrates struggle with that one, at least in my experience. But yeah, whatever the tenant situation, whatever the landlord tenant situation is at the time of the transaction, if there's a closing, that's what the landlord gets. No more, no less. A lease is a property interest, and so you can't give more than what you got. All right. Number 6, can you include unpermitted improvements in the heated living area calculation? I heard Kizzy talking about this a little bit. And I didn't hear her talk about this aspect specifically, but I think someone might have asked a question about it if I saw the chat correctly. In any event, the answer is yes. I don't recommend it, but yes. But any unpermitted improvements need to be separately identified. That is always been the commission's position as far as I know. Now, is there, to me, there's just too much of a potential for confusion if you're taking unpermitted space and including it in heated living area calculation. I don't like it personally, but if you really want, if this is something your client really wants, you can do it. Just make sure you are specifically identifying the unpermitted area. Furthermore, you're going to want to clearly identify any unpermitted area in the home because of paragraph 8H in Form 2T. And 8H, if you're not familiar with that paragraph, is the new governmental compliance paragraph. I've been doing a campaign ever since it came out July 1st. Please do not exclude this paragraph from your contract. It is there as much for agents protection as it is for the seller and buyer. It really is. It is not something that merely protects the buyer from unpermitted improvements. What it does is it puts the parties on a little bit more parity, but in truth, it really protects the agents a lot more if you think about it. The seller not being able to hide behind, a very low, or I guess a high bar, however you want to describe it. They don't really have a duty to disclose very much in a transaction. And we'll talk a little bit about that more later. But they just don't. We're a buyer beware state. So anytime the seller can disclose more, that is generally good for the listing agent and the buyer agent. And so I've been encouraging agents as much as possible. Don't try to get paragraph 8H out of the contract. Instead, as a listing agent, have a better discussion with your seller about what to disclose. Because if you disclose it at the front end, it doesn't affect the transaction at all. You just move on as if 8H is not there. Disclosure is the perfect salve to make sure that 8H doesn't bite anybody. And it encourages listing agents to have a better conversation with their clients. So just understand that. That's my little plug on that while we're in the arena there. All right. So moving on to number 7 here. The seller fires the first listing firm. Can the second firm take it? Yes, but you need to have a discussion with the seller. They may well be paying 2 commissions. Just because the sellers decide to walk away from the first listing firm doesn't mean the first listing is terminated. The seller can tell someone that they don't want someone to be their agent at any time. True for a buyer too. If a buyer wants to say, hey, you're not my agent anymore, fine, great, dandy, okay, see you later. Also, if you buy a house, I expect to get paid. That's what our agency agreements are for. If your client wants to breach a contract, there's probably not much you can do about that. You can't go to their house with a baseball bat and just make them, hire you back as their agent, let them keep doing what you're doing. They can walk away. But that doesn't relieve them of the consequences of the contract they signed. I've litigated, listing agreements, agency agreements of both, actually buyer agency and listing agreements. I've litigated them many times. They hold up very well in court. So if you got a client who really wants to, not do the right thing by you in your agency agreement, you just have a decision to make. You want to enforce it? Go ahead. You have a remedy for that in court. That's what the agreement's meant to do. But the second firm, most of the time what happens, I'm sure some of you are familiar with this, the second firm will offer a referral fee or something like that, something to at least, pay off the time of the first firm and then move on. But the first firm doesn't have to take that if they don't want to, or maybe their agreement's expired, who knows by the time it actually rolls around. Anyway, all this is separate from a protection period thing, which, mind you, I'll just say quickly, if you're in a protection period, the agency agreement expires, you're in the protection period. If the client signs with another firm at that point, it's going to cut off the protection period. And no, they're not going to owe you a commission. That's in all of our standard agency agreements on the residential side. So just make sure you're aware of that. All right, moving on. Number 8, the listing agent fails to disclose. Can you get the due diligence fee back? The answer to this is maybe. And again, as I said before, this is just not brokerage. You can make a request. If the parties can work it out by consent, great. You can maybe sign Form 390, and put it in writing, and then people pay whatever they're going to pay, and then everybody moves on. If you can do that, great. If you can't, just tell your client to go get a lawyer. If you email the hotline with that, which is probably one of the most common questions we get, that's all I'm going to tell you. So just understand that. Don't let your advocating for your client take you down a bunny trail of a legal matter when really you should just, stay in your brokerage lane and refer them to an attorney. What happens if you put NA in the due diligence period end blank? What is the end date of the due diligence fee in Form 2T? And the answer to this is nobody knows. Don't do that. Don't put NA in the due diligence period and end date blank. It can mean either A, there's a due diligence all the way to closing, or B, there's no due diligence period at all. Because technically speaking, that blank is, you're supposed to put the end date. It already says in the standard language that the due diligence period starts on the effective date. So if you don't put an end date, then somebody has a pretty good argument to make that it's going to last all the way to closing. Except when the parties sign the contract, they may well both, buyer and seller both believe that NA means there's no due diligence period. So what do you do with that? I don't know. Fight about it in court, I guess. But don't do that. Don't put it in there. We're trying to make some changes to that to maybe cut down on that. Yeah, we'll see. Number 10. There's a low appraisal and an FHA VA financing addendum. Is the due diligence fee refundable? No. The due diligence fee is not an other penalty under that form. A lot of people look at that language and the FHA VA financing addendum. The answer is no. It's just not. Number 11. Is low appraisal a material fact? And the answer to that is maybe. If you get, a couple of low appraisals, I strongly encourage you to disclose it. It's probably going to affect most buyers. It's probably going to be something most buyers would find to be a fact they would like to know before they make an offer. So I definitely recommend disclosing that. If you got just one, maybe not, but I would still recommend it then. Certainly multiple, I think you're definitely material fact territory, my personal opinion. Obviously, I'm not the commission, but that's just, if you want safe harbor, that's what I would do. Kizzy talked a little bit about this. Can you share inspection reports with other buyers? The answer to that is maybe. I always tell people, if you can, get permission of the inspector. The inspector probably owns it. Their contract with the client probably specifies that they own it. So if you get their permission, then it's probably going to be fine. But if you get a copy of one and it's just a copy, you could treat it like a library book. So if somebody wants to come look at it, fine. But you wouldn't take a library book out of the library, make a bunch of copies of it and spread it to the world. That'd be copyright infringement, right? Same thing here. Don't do that with inspection reports. You will, potentially suffer some consequences from that. So what I always recommend is get the inspector's permission if you can. Otherwise, if you got a copy and you want to use it kind of like a library book, somebody look at it, fine. I don't think that an inspector can do much about that. But I would not make copies of it and leave it on the kitchen table, for, buyers doing open houses to come look at. All right. Number 13, there's a small fence encroachment. Is it a breach? No, probably not. We did a couple of changes to Form 2T this last form cycle to make things like this. It has to be a material encroachment or breach in order to trigger those paragraphs in Form 2T. So likely not. If the parties really want to fight about it, they'll need to go to lawyers. But in my mind, if it's a small fence encroachment and the seller's still able to deliver title, probably not going to be a big issue. Number 14, it's a 4-bedroom house, but a 3-bedroom septic permit. Can you advertise as 4 bedrooms? Hopefully you all know the answer to this, especially after what Kizzy talked about. No, and no. Don't do that. Bad. And if you don't know, what the septic permit is, please don't just put a number on it and cross your fingers or something. Go have a septic inspector go out, try to figure out capacity, do something. Look at the permits. And if you, at the end of the day, if you can't, make a representation on that, then just don't do it. All right. Finally, we got, can a seller be required to complete a sale? The answer to that is yes. If a seller decides they want to walk away, the buyer's usually, as long as the buyer's not in breach, they're going to have a pretty good argument to make that if they want to make a claim for specific performance, they're going to have a pretty compelling case. So anytime sellers come to me with that scenario, I tell them, You might as well complete the sale. They got a lis pendens on your property. They've sued you. There's not much you're going to be able to do to wiggle out of this. Property is unique. Actually, I just filed one of these lawsuits a couple of weeks ago, and we're in the middle of that litigation right now. So I don't like the seller's chances, but they're trying, and I guess I can't blame them. They're allowed to complete their case however they like. All right. I know that was rapid fire, but hopefully you got a little bit out of that. It looks like we have a couple minutes for questions. So I'm going to open up the chat here. Let's see. And I'm going to stop sharing my screen also. Well, actually, you probably want to see that information a little bit longer. Here you go. I'll share this for a little bit while I'm reviewing the chat, and then I'll come back to it. All right. So Jason asks, if the seller passes away after the offer to purchase has been signed, how do you handle it? So I think all the parties need to take a pause at that point and figure out if they want to, or at least the buyer. The buyer really needs to figure out if they're going to proceed or not, because the seller simply is not going to be able to complete the contract. The interesting thing, though, is that upon death, immediately upon death, the property is going to go to whoever it goes to. So if there's a will, it's going to go to the beneficiaries of the will. If there's no will, it's going to go to whoever the heirs are, right? So there's an owner, there's always an owner of the property, always. But it's very likely that the new owner, upon death of the current owner, is going to be able to sell the property, in less than, I don't know, shortest length of time would be 6 months, I would think, but it might even be longer than that. It really depends on the situation. In any event, so after the seller passes away, buyer needs to figure out if they're going to hold on to it and wait for the seller to be able to complete the sale, even though the seller is going to be in breach long before, it even gets close to being able to close. But, or move on, if the seller breaches, it doesn't matter the reason why. If the seller doesn't deliver title on time at settlement when they're supposed to, then they're going to be a breach. And that means that the estate needs to pay back due diligence fees, earnest money, and, other damages that are permitted in paragraph 23 of Form 2T. So, oh yeah, thanks, Kizzy. Kizzy shared a link for unpermitted square footage that needs to be clearly identified and stated. And there you go. Appreciate that. Appreciate the link there. I'm just glad that she didn't write that I was completely wrong and that I was a horrible human and that I'm leading everyone astray. So I appreciate, maybe she's saying that privately. Anyway, that's good. All right. Nicole says, make the date of end of DD the same as the date of contract, no DD. Yes, that is a good option. If you make the end of the due diligence period, the same day as the effective date, there is no due diligence period. Right. Once it's signed, it's going to be effective. Due diligence period to be over. Is the information in the inspection report a material fact? The answer to that is maybe. Is a broken stove burner a material fact? I don't think so. Is the fact that the gutter doesn't, is not 2 feet away from the house, the output 2 feet away from the house, is that a material fact? Likely not, unless it's causing a foundation issue of some kind, right? Not everything in an inspection report is a material fact, but if you get an inspection report, you have a duty to disclose all material facts in that inspection report if you're a listing agent. Furthermore, if you get an inspection report, you don't just get to bury your head in the sand and not look at it. That comes up every once in a while where a listing agent doesn't want to look at it because they don't want to know any material facts. Well, guess what? That's no. If you get a complaint filed against you in the commission with that, another thing my firm does is we handle dozens of cases a year in front of the commission. I can tell you right now, they will have zero interest in listening to you on that argument. Do not bury your head in the sand when an inspection report comes up. You got to review it, look at it, and see if there's some material facts in there you need to disclose. Chris says, in my market delivery, the due diligence rarely happens when the buyer goes into contract. Most buyers are not here in town. What's being done to address this? This is a discussion that comes up all the time in the forms committee. There's been several proposals over the years that I've been on the committee to address this. At the end of the day, it's simply due on the effective date. So, if the seller chooses to work with you on that, then they do. Most of the times they do. But right now, there hasn't been a change on that. If you want to change on that, you'll need a custom addendum. If you can't find the septic approval, we are required to state bedroom number. What can you do? If you can't verify bedroom number, then you can't verify the bedroom number. I wouldn't put bedroom number. So I'm not sure what to tell you about that. You just got to keep digging until you find something that gets out there. Or if you have a number of bedrooms, but not a septic, then have a septic inspector come out there, if you can't find that information in public records. Could you add the number of bedrooms per the tax records and on the state remarks, no septic on file? I don't know. To me, that just at first blush, that smacks a little bit about what Kizzy was saying, that, don't just throw something out there and then put buyer to verify. I don't know. To me, that's just it's just asking for trouble. I guess I would put it that way. Could you do that? Yeah, but I would just make sure you have exhausted every single thing you can before you even, get into that territory. Amanda says, doesn't the buyer have the opportunity to agree to release their inspection reports on the due diligence request and agreement? Potentially, I have to review that form, but yes, that may be in there.
Yes, it is.
All right. The link, and Tiffany shared that with you again. That looks like all the questions. I only went 2 minutes over. That's impressive.
Thank you, John, so much for taking time to be here with us today to do your top 15. I think it was very informative for all of us, and I'm sure there will be more questions, and we have your hotline information, and we will be utilizing it as we see fit relative to some of the questions that have popped up. So thank you so much for that information. Are there any other questions before we let John go? Thank you so much.
See ya.
Next up is Daniel Peterson. I'm looking for Daniel to spotlight him right now. There are a lot of us on this call. Daniel.
Tiffany.
Okay, there you are. Okay, I'm going to share my screen real quick so that we can get started. Okay, first off, I just wanted to remind everyone today's risk management lineup was Lynn Elder and Kizzy Crawford from NCREC. John Waite just finished with NC Realtors, and we are moving on to Daniel Peterson. He is our E&O attorney that is typically utilized. Travelers is our insurance carrier, and Daniel is here today from Parker & Poe to talk about just topics that we need to go over. As we get started, one of the things that we didn't really talk about is realtor safety and making sure that you are constantly finding a way to protect yourself and to make sure you're dealing with the right person. We have seen a lot of legal cases pop up, as Daniel will attest to, that have you listing the property for someone who's not really the owner. And how do you check this in a day when identification sometimes can look perfect and look like it is? One thing I will note as Daniel gets started is, if you're a member of South Carolina Realtors, Forewarn is an app that you can utilize. It is something that if you're a member of Canopy Realtor Association here within the next 2 to 3 months, you will have a free membership to it as well. If you're in any other part of the state, Forewarn is a great app to use. I've had several agents in our firm that have utilized it and realized that they were about to show properties to someone who had written fraudulent checks to buy houses. So I saw Nick Bailey, who is our CEO from the stage earlier this spring, use Forewarn, asked someone in the audience for their name. He knew they had a speeding ticket. He knew that where they lived, the last cars that they had driven, so that you could then identify when you pull up to a listing, if you do not know someone, or to the buyer agency piece, that you've got some protection of yourself. We take realtor safety extremely important here at RE/MAX Executive. And I just want to remind you, if you have access to Forewarn, utilize it. Otherwise, make sure you're taking the steps to make yourself safe. But Daniel, if you want to talk a little bit about what you've seen relative to, I would say, bad actors taking over property and acting as the seller.
Absolutely. First, let me just say thank you all for having me today. I really appreciate, Tiffany, you inviting me to take part in this. Look, when you've got folks that are, this kind of app is a great thing. Make sure too, you can also call the property records office in your local jurisdiction, verify who the owner is at the outset, and you just gotta. We'll talk about this in a little bit, but really be vigilant in this era of kind of fraudulent behavior. Again, not only with people posing as property owners that aren't, but also with respect to like Wirefraud, and we've already heard some about today.
Thank you. And then again, driver's licenses, you need to be careful as you're looking at them. You can also call and validate with the issuer of it to confirm that it's a valid license. I've had someone do that recently that found out that it was not a valid license, looked valid, but that license number was not of the right record. Okay, Daniel, tell us a little bit about measurements and requirements. We've talked a good bit about it on our call, but I definitely want you to reiterate it.
Just to reiterate, and maybe, to kind of tell a story. And let me first say, kind of my general disclaimer. Obviously, anything you guys encounter is going to be very fact specific. And so if you get a complaint or a letter of inquiry from the commission, certainly if you get any subpoena or legal process in a lawsuit, you need to contact your broker in charge, and they'll get you in touch with and then likely me or my team, and we'll work from there. So anything I say today, is just kind of the guideposts. I think, as we heard earlier, you guys heard it straight from the source with Kizzy on the call. So, just that's, I just want to kind of provide that general disclaimer. As far as measurement requirements go, again, we've heard some about that today already, and it's really important to not affirmatively stake yourself out on a measurement in which you are not, in which you have doubt in which you have not personally observed. You cannot just rely on a tax document. You cannot rely on somebody else's measurements out of hand, and or certainly not your client's measurements. And that's, really important to make sure you're following up, doing it yourself based on the commission's kind of handbook on how to take measurements. And again, though, if you do have multiple measurements, it's a good idea to have it documented in your transaction file and to kind of disclose sort of all of the above sort of thing. That keeps you protected.
Next up, we've talked a lot about septic permits. It is something that we see as a firm across the Carolinas as something you've got to be diligent about. It is something that Daniel has defended us on, and I want him to speak to it to make sure that we're all on the same page.
Yeah, again, this, kind of the common theme of the day, it seems like, with misrepresentations and what is material and what is not, is, really taking that extra step and verifying things, and not, even if you've sold homes in one particular neighborhood that are all hooked up to city, the city sewer, make sure you're verifying that new listing that you've got, okay? Because I've seen it where it's happened for septic systems, and it's happened for something like cable and internet access, where the entire rest of the neighborhood has one sort of system, and then you've got this one outlier that wasn't verified. So again, you've got to make sure you take that extra step and get that verification from the appropriate authorities, and to document that you did that. That's, you got to show your work, sort of thing.
Next up is docks, and Daniel and I talked about docks in our South Carolina session. Duke Power regulates a lot of the lakes throughout the Carolinas, and then there are a couple of other groups that regulate lakes that are not regulated by Duke. They own the waterways, and so they have dock permits on the docks. It's important, one, to know that you've got a dock permit, and it's usually a metal piece probably about 4x4, 4x6 that is on the dock, and it has a permit number on it. You can't just trust that that is the right permit for the dock. You need to verify it. The issue comes in that Duke will only speak to the owner of the property. They will not speak to the prospective buyer or to the agent. So you need to make sure your seller is upfront with you and that you can get documentation, and you ask them to ask for it, because Duke will provide it to them. And you need to know that they have had all of the work done with Duke's permission. You cannot change anything on your dock without getting Duke's permission, one. And two, you need to make sure that when the lakes weren't all that popular and they were less populated, that someone didn't just decide they were going to move the dock down the road, or the swim setup down the water, I should say, not road, to the next house, because things like that happened back in the day and you don't want to get in trouble for it today. So when you're thinking about docks, you always need to make sure it's permitted and that your seller's on board to get the records if they do not have them. Getting those records in writing and not having hearsay from your seller is extremely important. Also, if you do not sell or buy on the lake often, you need to remember that transfers must happen. The dock permit is per owner. So just because Daniel owned the property yesterday and I own it today doesn't mean that I have the dock permit in my name. I've got to pay a fee, which I think is around $350 to transfer that over. So it's important that you know these things if you're going to sell on the water. And if you are, we've had Duke come out and speak before. We probably will have them again soon, but just be very careful on docks. Daniel, is there anything else you'd like to add to that?
Yeah, just to, again, kind of, using docs as an example of things of kind of all things that we've been talking about. You've got to can't just duck your head in the sand on this, as Tiffany kind of implied there. You've got to get your seller to call due because they won't talk to you. And you know, as the E&O guy here from that lens, you want to make sure you're documenting that you told them to do that, and that you've got documentation from the seller that shows that they did in fact go do that, and that they've got the information that's needed, and that you're telling folks what the next steps are, whether you represent the seller or the buyer, on getting that doc transferred in name. So.
Wire fraud, that is an important issue, and Daniel knows a good bit about it. And once he talks, I'm going to share a quick story to bring you up to date on a new issue that's floating around the Carolinas.
Thanks, Tiffany. Yeah, this is something that has just exploded over the last several years, and particularly after COVID. I think for whatever reason, I've seen an increase in these kind of claims. And you know, a couple of pointers. One, you know, you really shouldn't be in the position of passing along either your client's sensitive financial information to closing attorneys, or really even connecting, other than in a very general way, closing attorneys with your clients. And I say that because closing attorneys are prime targets for wire fraud, and that these fraudsters are very, very adept at looking like a legitimate law firm. And it's gotten where sometimes it's going to be hard to tell. Back in the old days of like 2019, you'd have a lot of bad actors that had, you know, poor grammar, kind of some telltale signs of wire fraud. They're getting more sophisticated. They know, I mean, we've got this dawn of AI that things can be drafted from. So a couple things. One, we preach and harp on responsiveness to your clients, and that is absolutely important. However, these devices, these cell phones, can be a blessing and a curse when it comes to this, because one thing I've seen in a case is that somebody posing as a real estate agent's client's closing attorney emails the agent and says, "Hey, I can't get in touch with your clients. Can you please pass on these wiring instructions?" So the agent received this on their phone. And again, this is something that you would not think to even question. Forward to the client and say, "Hey, this, you know, please pass this, please get in touch with this closing attorney," and we're off to the races from there. The reason I bring up the cell phone component of this is that often on these email clients with cell phones, you can't see where the origin email address is unless you click through. So all they have to type in is, let's say it's me. If they're posing to be me, they have to type in the email account they've manufactured to say Daniel E. Peterson. And it looks like to you on a phone that I'm emailing you. They may even have the firm's graphics and the email signature on there. It looks very legitimate. But if you had clicked on the name, you'd see it was dpeterson855555@gmail.com. And that's another point. I know in the real estate industry, it's very common to have, you know, kind of different kind of email addresses from different email domains. In my experience, a law firm will always kind of have the like my law firm, @insertlawfirm.com, @parkerpoe.com, you know, moreandvanallen.com, that kind of thing. It will never be sort of a domain where it's not. And if it is, there's an easy solution to that. Look the law firm up on the internet, make an independent phone call, and verify the sender of that. And that's, again, really even just assuming that you're in that role of acting as intermediary between these two. That really should be between your client and the closing attorney. But if you do receive a message, verify. Taking one step back further from that, the other issue I've seen is, look, we've got forms that tell folks all about wire fraud. I'll tell our clients all about wire fraud, and it's part of the packet of working with real estate agents and the listing agreement, and there's even a call out in the listing agreement. It is imperative, though. I'm looking at it from the lens of when you're sitting in a deposition, being asked questions by a hostile attorney. They're going to say, "Okay, I see." You know, you're going to say, "Well, look, they signed these documents. They acknowledged that this risk, that, you know, what to do to avoid wire fraud." And oftentimes you're gonna be facing an allegation of like a breach of fiduciary duty. But look, these guys said, I signed these documents, I didn't really read them, I was just kind of rushed through it, encouraged to sign, and these guys are the experts. They ought to have told me that. Let me tell you from my lens, if you just stop at that kitchen table when you're talking to a client and going over the listing agreement and all the documents, working with real estate agents, if you walk, and this is good just generally to do, but specifically with the wire fraud piece, and stop and spend a minute on it. Stop and have that conversation. One, you're going to have the positive impact of them remembering that, hopefully. And look, even if they don't, you can say in a deposition in court later to the real estate commission, anybody who asks, look, it is my custom and practice to walk through this disclaimer, walk through this warning with my clients very expressly, and to explain to them what their obligations are, my obligations are, and what to expect from like a closing attorney. If you do that, you are going to be on much better footing than saying, well, I think I took them through it. So just get in the habit of stopping at the wire fraud paperwork and explaining your clients' obligations, and that they need to be, for example, calling to verify wiring instructions with the real estate attorney. Heck, when I bought my house, I went and drove, because I was completely paranoid given my profession. I drove to the closing attorney's office and said, hey, I got this message. Is this your wiring information? So I could go on and on. This could be an entire hour of me going on scaring you about wire fraud, but really and truly, take it seriously, folks.
And Daniel is certainly right. Bad actors have gotten more and more sophisticated. Their language is better in emails, but they also are, if they have your client's email, texting them immediately after what they call an encrypted message and saying, I just want to confirm you received our encrypted message, and this is our process. So they're making it sound very legitimate. So you need to be having that conversation on wire fraud often, at the beginning, but all the way through the process as reminders, and putting it in writing as well is a great practice. Material facts. Daniel's an expert on material facts. And so
I'm not allowed to call myself an expert, but thank you, Tiffany. I appreciate that introduction to this. We definitely, in the sense of we handle these types of claims all the time. And I think you've heard it on repeat earlier today, and now you'll hear it again for the third time from me. This is the biggest area where agents find themselves in trouble, or alleged trouble, as we like to say in my business, on both regulatory complaints and then in lawsuits. It's kind of to put a finer point on what we've already been discussing. It's about taking that extra step, not taking the attitude of buyer beware, or look, my seller told me this and I took it on faith that this was true, but where there are things that you can affirmatively and independently verify, please go ahead and take the 5 minutes it takes to do that, because it will save yourself. If nothing else, it saves yourself a lot of time and heartache when there is a complaint. As I tell folks, clients from all across the business spectrum, anything I do with folks, look, anybody can file any complaint they want to. I'm not here to tell you how to avoid having a complaint filed against you necessarily. People are going to be upset. They're going to do things that are they're going to file a complaint if they want to file a complaint. But what our goal is to put you in the best decision or best position to defend yourself in front of the commission, to explain, like, look, here's my transaction file. Here's all the documentation I have of disclosing these material facts. Never leave it, just to a kind of conversational tone. It's good to have conversation, but please go ahead and follow that up. And I'll go ahead and take the opportunity here with the material fact section too, Tiffany, if I may, to kind of talk about documentation as well. Because again, when so often, particularly in kind of an open house context, you're talking with folks, it's rapid fire, and you're trying to do your job, right? Just when you get into a more, when you're in that discussion with an interested buyer, whatever, anybody inquiring, make sure you're not only documenting the conversation, but also saving those that documentation. For instance, if you're talking with one of your clients or another agent through text, don't let your text expire. Okay, like say, make a habit of, if at nothing else, screenshotting your text and saving it in the transaction file. Ideally, I would advise against going too far into texting folks in your practice. I'd prefer it to be just email, but I know that in the day of client expectations on responsiveness, that's just not practical. So please do save your text messages, particularly when you're discussing anything that is of a material fact nature, and document your file. We've already talked about what the key material facts are in any situation. And one thing, kind of anecdotal, is emphasizing that there's, kind of material facts we all know about. But then there's also this kind of dependent situation on either your client or, the buyer. If you're representing the seller and a buyer has voiced a particular issue of importance that might not otherwise be seen as a material fact, if you have knowledge that that's an important and critical issue for them to purchase that house, or what they're going to be offering on that house, and you know something that runs contrary to that statement of importance, you've got to disclose it. Err on the side of disclosure, and please again document that you actually had that conversation. It's as easy as following it up with the other agent saying, per our discussion, there is no high-speed internet on this house. Just again, for example,
Hold on there. So next up, flood zones, watersheds, and land uses. Tell us about what we should know and be careful about relative to these three items.
Yeah, absolutely. The flood zones and watersheds specifically, again, make good use of kind of publicly available information, even get familiar with your FEMA flood map, and call your local municipal or other local government, not representatives, but employees, kind of verify, okay, I see this is in the watershed, and talk about the land uses, specifically where there's projects that are either planned and have been advertised, or have been sitting for an inordinate amount of time. I had a case one time where there was a city project that had just been sitting for, literally years, but there was information available about it online, and checking kind of like the GIS mapping site, if your jurisdiction has that, if your jurisdiction has that capability, it's an easy way to access it, because what happened in this particular situation is after years of dormancy, a seller had negotiated, had been approached by city authorities. The city had acquired a temporary construction easement to do work on the property when that project was to be completed. And then everybody in that neighborhood just assumed the project had died, gone away. Well, as it turns out, of course, for 6 months or so after the property sells, the project reignites, and all of a sudden there's city personnel on the buyer's property. And we had represented the buyer, Remax, meaning Remax had represented the buyer, and it was a situation where there was it was a discussion over whether what was reasonable for the real estate agent to have done in following up. There was a lot of kind of interesting fact-specific issues in that case, but just again, the easiest thing to avoid yourself a lot of time and energy is to call often, to follow up with folks, use your resources.
And document that you did so, screenshot things that you looked at, make records of phone calls that you've had.
Absolutely. Yeah, I forgot to say that. When you look at a flood map, take a screenshot of it. And again, that's one extra step that takes you 2 minutes. And it just, yeah.
I believe a lot of our MLSs have layers in their mapping. And I know in Canopy, we have a layer that is for flood zones. And so check your local MLS if you're not a part of Canopy to see if you have that. If not, FEMA is very easy to walk through as well and get clear on that, because flood zones are in places that you least expect it sometimes as well.
And if you're in Charlotte, specifically, the city of Charlotte also has, it's called Virtual Charlotte, just Google it. And it has layers that probably are in line with MLS and Canopy. showing you that. And any one of those resources shows that you took that independent step of verification.
Okay. Stay away, refer when you aren't familiar. Often we have access through MLS, particularly more so here than ever over the next couple of years with data shares with people far into the mountains, down to the coast, to Charleston. If you are not an expert in that area, refer it out. It's not worth risking your license. If you've never spent a good amount of time or lived in a certain community and worked in a community, the likelihood that you're an expert in that community is slim. So if you've never been there, think about it. Daniel has had definitely cases relative to the expert piece, and that is an issue that we will see more and more. So make sure that you're working through that and talking to your broker in charge before you just start randomly heading out to different parts of the states.
Absolutely. And to follow up on that, that kind of goes, I heard some commentary about advertising too. So just be thinking through how you're advertising, what expertise you're putting yourself out there, because people will hold you to it.
Working with real estate agents and South Carolina agency disclosures. This is, Daniel, substantial contact disclosure information, making sure that you're having the conversation and you're going through the facts. As we look at this as well as agency documents, let's talk a little bit about where you see people trip up.
One thing that kind of jumps off the page at me is not completing documents. You've got a plethora of resources with standard documents, making sure that even if something isn't applicable, fill in the NA, put not applicable in there, because then it removes any question that you just happen to skip it, that you just happen to, that you ignored it. That's important to do, because again, looking at it from a very cynical point of view, you're going to have somebody on the other side questioning whether you paid attention to it. And again, working with real estate agents, documentation, when you're sitting at that proverbial kitchen table and talking with the prospective client, take a minute and just kind of step them through it. I know that sounds obvious. I'm sure all y'all are doing that. Just a reminder that that is a best practice. So you can, again, cynically say, from my perspective, it's, you're sitting in that chair and you can say, look, it's my practice to walk them through X, Y, Z and explain exactly what our responsibilities are.
And as we explain those responsibilities, some of the things that you need to do as you're adding value as a buyer's agent, as a listing agent, is making sure that if you have access to a property report, which you do through executive title, and a clue report through executive insurance, that you are giving that information for your buyers, for your sellers, so that they have it and that they can utilize it, particularly on the flood zone piece. On the flood zone piece, the clue report provides flood zone, and the property report provides information in terms of potential judgments and liens, outstanding deeds of trust or mortgages that have not been satisfied, even though that they should have been, so that you can handle those issues before you get to closing. That is part of being a realtor, is providing the facts and the information that your clients need to make a reasonable decision. And sometimes it's giving them the time frame to clean something up if they need to clean it up. Surveys are a topic. And with executive title, we have enhanced policies. With the day and age of people as bad actors acting like they're sellers and selling property, title insurance is going to protect you on that. Also, from issues coming up with surveys, title insurance is going to protect you on that. We work with preferred attorneys so that you know that they're going to get the job done for you. They're going to be there to answer your questions when it comes to closings, and they're going to be there after the fact in case something pops up. If you aren't having your client to get a survey, to do enhanced policies, working with preferred attorneys, those are some of the things that you need to be thinking about as that value add. Surveys, banks don't typically require them anymore, but you wouldn't believe what people find when they pull a survey if they don't have one. So you need to be careful if you're not recommending.
Well, please do that. I recently had a client that this very issue came up, and it was so easily avoidable if the survey was done.
Next up, pull the deed. The tax record's not always correct. It could be that they missed something. It could be that they don't report information until the end of the year, or it could be that someone else has been paying the taxes for years and their name just happenstance to get on that. The deed's always going to be the most accurate way to find who owns the property and what actually is owned by them. Daniel, any comments on this one?
That's just to verify what you're saying is absolutely what you should be doing.
Okay, and then you already said, use NA, don't leave blanks in contracts. People could fill something in and you not realize it, and then after the fact, you're stuck.
That's right.
Delivery of checks. U.S. Postal Service is not the best way to deliver checks in our business. It's not always reliable. We've had a number of late delivery issues and circumstances where our client could have been in breach of contract because they used our advice or non-advice and just put the check in the mail. Yes, that date and timestamp on it is great, but once it gets lost and the seller sends out that 1 business day notice or banking day notice to deliver funds and you can't do it, that's a problem. So you need to make sure that you're being protecting of your client's checks. And use the proper forms to terminate. And Daniel, what cases can you share with us where you've had an issue on terminations?
Look, kind of the quintessential thing for me is look, I can argue a number of things in court, for example, that terminates the contract. The easiest and most direct way to shut any of that down is exactly this: use the standard form at your disposal. You know, I mean, could I argue that an email does it? Sure, but I don't want to be making that argument in court. Please use the forms to terminate a contract.
Okay. And then communication in writing. Verbal is great, but as per our discussion and whatever you discussed after is huge. It will help Daniel protect you.
Absolutely. And I mean, again, not telling you not to talk on the phone and talk in person. That's part of our jobs as professionals in all manner of industry, particularly y'all's. But, you know, for any follow-up documentation you can show that a conversation actually happened is great. And I know, again, a lot of this is kind of behind the curtain sort of, you know, stuff. But honestly, if you think a relationship can't go south, I've seen best friends go after each other in these sort of contexts. So just, you know, always think of it, always watch your six, so to speak, is the way I like to say it.
Yes, famous last words. Oh, we're friends.
Yeah, please. Yeah, no.
Yes. So talk on your phone. This one is here because so many of us will only text or will only email. And what we're trying to convey probably isn't what the other side is hearing. Perspectives of what the text actually means and the tone of it are so different. Pick up your phone. If you're a listing agent and the buyer agent is calling you, don't be shy. Talk on your phone, but then send the validation in writing. I know often you want it in writing, but that communication that we have, the verbal communication, is key to success.
Particularly if something is going wrong and it starts to escalate, people can misread tones. And it sounds kind of, as Tiffany said, kind of counter to what we've been saying about written communication. But a phone conversation can do wonders to de-escalate and then follow it up with.
Definitely. Get your client's permission to share information. You can't just share, you have multiple offers. You can't share anything unless you have your client's permission, unless it's a material fact. And not having permission can get you in a precarious situation. And finally, don't ask your Facebook friends. Ask your broker in charge, ask myself, ask a leader in the company. When I go out to Facebook sites and I see, and don't answer questions on Facebook. The more you answer those questions, the more you have some liability in the whole tenor of things for not directing people back to their broker in charges. If I had a dime for every time I looked on our Charlotte message book or any realtor book and the questions that were asked that made me cringe, I would definitely be a millionaire just by the Facebook site. I am always going out there to look to make sure there's nothing that we aren't answering for you guys. But please, 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 if you see your friends and colleagues out there, don't answer the question. Tell them to go talk to their broker in charge, because answering the question adds to your liability. I was with one of our NC Realtor commissioners or NCREC commissioners last week talking, and he was all over those people out there that are just answering questions have so much liability. So be careful, because the real estate commission is starting to get tighter and tighter on everything they do. And we want to make sure that you are protecting yourself. We are realtors. It is our profession to make sure that we're adding value and helping people through the biggest transactions in their life. And the more you can show your clients that you're adding value, because you do every day, is important. And we want to make sure that you feel like we are providing you with every opportunity to do that. So if you have any questions or you need help, don't hesitate to reach out to your broker in charges. And again, we have preferred closing attorneys to help with the safety of our clients. And so if you're not using a preferred attorney, check into it so that we can make sure that everyone is secure as possible. And I want to take this time to thank Daniel Peterson with Parker Poe. He is a tremendous asset to our company and to our agents who need them when they do need them. And so thank you so much for taking your time today to share this information and for being there as we need you day in and day out in our real estate world.
Thank you so much for this kind words, Tiffany. I appreciate you all tuning in and listening. Thank you.
Thank you. Well, again, we appreciate you all being here as well. And thank you so much. If you have any questions or you need anything else, don't hesitate to reach out to us. Have a great afternoon.
Thank you.